The deadline of a month of 28th January goes away.
What was the need right now for putting across this 10% cap?
How would a single allottee or a home buyer supposed to know? Because there is no public data available for that.
5.4 lakh apartments, 1600 stalled projects.
All the 400 cases of home buyers would have got dismissed.
Not only impacts financially to a developer, the credibility of a developer goes for a toss.
Nobody is saying you refund their money and do not complete the project. No.
Hi, welcome to the Property Show. I'm Jayashree Kurup. I'm editor, MBTV. And today we're talking about will consumers benefit from the Supreme Court order on the IBC Ordinance. Piyush, I'll come to you first. What was the ordinance and what is the stay currently?
The ordinance primarily deals with classification of class of creditors. Any allottee in a real estate project, they defined as per RERA allottee, will need to have 10% or 100, the same figure, whichever is less for a real estate project. The ordinance stated it has to be a joint petition on behalf of 100 buyers or 10%. It has to be a single petition.
Right.
And also, it stated that all the pending matters where an IRP is not appointed or a petition is not admitted, it will be having a retrospective effect. Means they gave the ordinance stated a time period of a month, 30 days from the date of ordinance. So from 28 December till 28 January 2020. Only 30 days were given to pending petitions to comply with the ordinance, right, which is that every single home buyer in a petition will have to get 100 or 10% mandate for his joint petition.
I'm going to come to a home buyer. Vikram, which project are you from?
We have a project in Faridabad by the name of Anand Villas from Puri Constructions. And as Piyush ji has said very clearly, we were actually at the stage where our order was reserved on 24th of October. So when the orders came across on, I think 3rd of January, because of this amendment, it went across into the same, you have to do the 10%. So 3 months of time lost, and for no mistake of us. Secondly, I really don't understand what was the need right now for putting across this 10% cap. Takes away, first of all, the legal right of a single individual to file across a case. It happens, it might be a situation wherein a single home buyer has a problem with a builder. So the right has been taken across.
What happened to the consumers who had filed their petitions before that? If they were individual petitions, could they combine it then?
A joint petition would mean that either all of them club into any one single petition. But again, they will have to be 100 or 10%. The biggest difficulty was there was no database to know what is the number to reach that 10% mark. So the huge ambiguity which was there in the ordinance, that how would a single allottee or a home buyer supposed to know, because there is no public data available for that.
And currently what the Supreme Court has said is it has maintained status quo for those who have already applied.
Supreme Court has issued notice to the Government of India and Ministry of Corporate Affairs. And secondly, Supreme Court has ordered the status quo granted as of today on all the pending cases. So the real implication would be the deadline of a month of 28th January goes away. So as on date, no home buyer whose case is pending before NCLT is supposed to either amend his petition or supposed to get into that mandate for now.
What happens to those who were planning to go to the NCLT and haven't gone yet?
Supreme Court has not stayed the ordinance for now. Supreme Court has issued notice and status quo for all pending matters. For anyone who wants to file now, so far the registry of NCLT is not accepting matters. That's a huge respite for two reasons, because the court fees at NCLT was substantial. So all these buyers had paid 25,000 rupees court fees and IRP consent fees plus the legal expense. So in case the matter would have become infructuous, though they would have come under the group capacity maybe sometime later, but they would have at least lost $1 lakh rupees for the already pending litigation. And secondly, the time frame. So somebody's matter would have reached a final stage, arguments would have happened, or pleadings would have got completed. So his matter is going to remain stay at the very same instance, and whenever Supreme Court decides, maybe in 2 months, 3 months time, his matter would be taken from that very stage. So he's not going to lose much time on that.
Sadiq, the NCR region has been the one that has the maximum number of cases. You know any numbers? You want to go with any numbers? Anarock numbers?
There are individuals who are approaching NCLT, and the projects are on the verge of delivery. And since this one individual is going and with the proceedings, rest of the buyers are also suffering with this consequences, because the projects are getting stalled, there is no proceedings, and which is also impacting rest of the people. Today, if you look at NCR holistically, or even India holistically, 5.4 lakh apartments, 1600 stalled projects. It's a huge number. Now, if you look at the entire scenario, ideally my objective as an individual would be to provide home buyers with a solution. Now, when individual home buyers are going into NCLT, this is leading to some problem at a certain time, and which is impacting the rest of the home buyers as well.
Don't you think that the whole NCLT process itself has been delayed?
In case the stay would not have been there, what would have been the scenario? I ask myself. All the cases pending before NCLT, 400 approximately cases, let me say only 4 or 5 were group petitions which would have been able to clear that mandate.
Right.
All the 400 cases of home buyers would have got dismissed.
Right.
Secondly, there would have been a complete chaos in the market. Now, what does this ordinance do? Let us ask ourselves.
Yeah.
It mandates 100 people to come together. Now, you are giving a tool in the hands of buyers. Go form your respective groups. Collect information from whatever sources you have. In case an allotee, a home buyer will have access to those details, numbers and the addresses of other allottees. And they form a group of 100 people and they file an NCLT matter. Now, do you think a real estate company will survive? Or if I have to answer Sadiq's answer, that what will happen to that company where a project is almost complete?
Right.
The same problem would come. Now, second thing is, as Sadiq mentioned, that a project which is about to get completed, what will happen to those projects? Now, whenever an IRP is appointed for any company, there was a standard order usually passed by every NCLT that the company should remain a going concern. So, in case a company is completing a project or is about to complete a project, only 5% is supposed to be. So, IRP will not halt the process. The moment you have that order.
But here, Piyush, how many resolutions have we had from the NCLT?
I will give the exact timelines and then let us go to that question that how many resolutions we have. July 2018, the exact date when the Parliament gave the home buyers the right to approach NCLT. The first date. January 2019, so the period was only 5 months for the home buyers to approach NCLT. So January 2019 till August, there was complete stay again. From 9th of August 2019, we start again. So the deadline is 9th of August till 28th December.
The Pioneer Urban Judgment.
Pioneer Judgment. So technically it is less than 4 months.
How many cases would there be where the NCLT is actually taking projects to closure?
Not a single real estate company has completed that period of 9 months and has gone into liquidation. So the answer is very positive.
With individual consumers going to the NCLT, do you think that this would have slowed down the process of completions and access to finance?
Definitely, yes. Reason is that we have seen instances where the projects are almost complete. Yet any 2-3 individuals, consumers have gone to the NCLT and they tried to blackmail developers as well.
There have been instances where consumers have actually gone to the NCLT and then taken an out-of-court settlement with the developer. A very large number of them. Piyush, you want to comment on that?
Is there anything wrong in it? So I ask myself, if a financial institutions, there will be more instances where a bank has taken a company to IBC, same instance, Section 7, file an application, and they had an out-of-court settlement.
Except that this is a long gestation project with multiple buyers involved. If 5 buyers take their money out in a depressed market condition, will the project go through to completion? That's what we're putting on the table.
Now, not even 5% of home buyers go into litigation till date. So if I ask myself, if I'm a developer...
So for that 5%, should the 95% not get their houses?
Absolutely not. The point is that 5% in case, for example, somebody has invested his money waiting for 8 years. He's entitled to refund, that's the law. So nobody is saying you refund their money and do not complete the project. No. You cancel his unit, refund his money with whatever interest you can and sell that unit in the market. The point is, once you're doing any business...
But the market is not buying those units today.
If contractually you are entitled to, all this builder-buyer agreement had given, plus the law of NCLT in Supreme Court, gave that right to a home buyer to exit. So immediately the moment somebody has that right and invokes that right, you cannot say, no, I'm going to complete. Yes, very right. You give that money, you should have that liquidity.
So I want to add up to Piyush's point is that, yes, 5 out of 1,000 people going and doing an out-of-court settlement, yes, but I have seen petty cases like, interest not paid by a developer is also going to NCLT. Now what is happening is this is misleading. It is right, as correctly said, there are buyers who are genuine buyers, but simultaneously this whole scenario also not only impacts financially to a developer, but also there is a sentiment which goes wrong. The credibility of a developer goes for a toss.
Developers' credibility has gone for a toss over the last few years because they have not delivered. Vikram, help us understand the nuances of your case.
It's always been the buyers who have been asked to negotiate and accommodate, wherein they are the people who have been running the show. If you delay, the builder will charge you 18%. If you delay in payment of that 18% interest, again he will charge an 18% on top of it. So why should a consumer be asked to not go to NCLT?
I'll take your case. How many of you went to court together?
We were around 24 people who were there.
And
26 in total.
Did
yeah.
you file individual cases
Yes,
or together?
all individual. So there were two projects in which the people have filed. 3 was in one project and 23 of us in the other project.
So why don't you file as a group?
We will file going across together.
Because you have court fees, you have IRP fees, and you have your lawyer's fees.
All the 23 people that which were earlier, they filed individually. They had their own points. They have their houses in different towers, and depending upon, so you cannot construct all the towers together. Yeah. There has been a delay in one tower or the two others, so everyone has their own problem.
Jayashree, somebody like Vikram can be lucky to have 23 people along.
Yeah.
What about somebody who only has a single petition before NCLT? We know a lot of buyers.
Right.
They cannot find, they do not have any means to find out any group.
So what I've actually noticed is that buyers do form themselves into groups and WhatsApp groups and other groups.
Technologically, they are well armed today.
Yes. NCLT is also not going very fast, and builders normally are looking to settle out of court, right?
The law is for the developers to comply with things. Nobody is asking for an illegal thing to be delivered. All these out of court settlement have been for the legitimate dues as per the contract.
Whatever IRP orders have been come, or the IRPs have come across, except leaving across few like JPs or the other ones, the other orders, the builder themselves have been eager enough to settle it out.
Once the IRP comes, is the builder still in the project? The builder is more or less out of it, right?
Technically, though informal, the process of out of court settlement, but very much recognized in the pioneer judgment also. So Supreme Court said that you have technically 3 choices. So for instance, somebody has taken in a single buyer who's disgruntled, who may need money for whatever, like the cases of cancer or daughter's wedding we're discussing about, which may be very few cases may be at hand. You have 3 stages to settle those cases. In case you are not, then IRP is going to take charge of the company. He will restructure you. So, and the other argument, with no IRP or restructuring process taking any right from the developer. So the court said it's a kind of a medicine for a man who wants to heal. So your company wants to heal, even the management of the company will benefit from the IRP process.
But the management is removed from the process, right?
What happens is management is supposed to be, as per the mandate, required to assist the IRP in providing all assistance, all documentation, book of accounts, whatever assistance is required.
So there you are. It's a status quo that the Supreme Court has ordered, that whoever went to the NCLT before the ordinance was passed, there's a status quo, they will be heard. The orders have not started coming yet. It is more or less a period of wait and watch. The larger issue is that can a consumer body form a group if it does not know how many units were sold? And that's where the Supreme Court has ordered status quo. Thank you so much for watching The Property Show. I'm Jayashree Kurup. Please subscribe to Magic Bricks on YouTube and click the bell icon to get new videos.